The 13th Amendment to the United States Constitution abolished slavery and involuntary servitude, except as punishment for a crime. In Congress, it was passed by the Senate on April 8, 1864, and by the House on January 31, 1865. The amendment was ratified by the required number of states on December 6, 1865. On December 18, 1865, Secretary of State William H. Seward proclaimed its adoption. It was the first of the 3 Reconstruction Amendments adopted following the American Civil War. Slavery had been tacitly enshrined in the original Constitution through provisions such as Article 1, Section 2, Clause 3, commonly known as the 3/5 Compromise, which detailed how each state's total slave population would be factored into its total population count for the purposes of apportioning seats in the United States House of Representatives and direct taxes among the states. Though many slaves had been declared free by President Abraham Lincoln's 1863 Emancipation Proclamation, the post-war status was uncertain. On April 8, 1864, the Senate passed an amendment to abolish slavery. After one unsuccessful vote and extensive legislative maneuvering by the Lincoln administration, the House followed suit on January 31, 1865. The measure was swiftly ratified by nearly all northern states, along with a sufficient number of border and reconstructed southern states to cause it to be adopted before the end of the year. Though the amendment formally abolished slavery throughout the United States, factors such as black codes, white supremacist violence, and selective enforcement of statutes continued to subject some black Americans to involuntary labor, particularly in the South. In contrast to the other Reconstruction amendments, the 13th Amendment was rarely cited in later case law, but has been used to strike down peonage and some race-based discrimination as badges and incidents of slavery. The 13th Amendment applies to the actions of private citizens, while the 14th and 15th Amendments apply only to state actors. The amendment also enables Congress to pass laws against sex trafficking and other modern forms of slavery. Text. Section 1. Neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. Section 2. Congress shall have power to enforce this article by appropriate legislation. Slavery in the United States. The institution of slavery existed in all of the original 13 British North American colonies. Prior to the 13th Amendment, the United States Constitution did not expressly use the words slave or slavery but included several provisions about unfree persons. The 3/5 clause allocated congressional representation based on the whole number of free persons, and 3/5 of all other persons. This clause was a compromise between Southerners who wished slaves to be counted as persons for congressional representation and Northerners rejecting these out of concern of too much power for the South, because representation in the new Congress would be based on population in contrast to the one vote for one state principle in the earlier Continental Congress. Under the Fugitive Slave Clause, no person held to service or labor in one state would be freed by escaping to be another. Article 1, Section 9 allowed Congress to pass legislation outlawing the importation of persons, but not until 1808. However, for purposes of the Fifth Amendment, which states that no person shall be deprived of life, liberty, or property, without due process of law, slaves were understood as property. Although abolitionists used the Fifth Amendment to argue against slavery, it became part of the legal basis for treating slaves as property with Dred Scott v. Sandford. Stimulated by the philosophy of the Declaration of Independence between 1777 and 1804, every northern state provided for the immediate or gradual abolition of slavery. Most of the slaves involved were household servants. No Southern state did so, and the slave population of the South continued to grow, peaking at almost 4 million people in 1861. An abolitionist movement headed by such figures as William Lloyd Garrison grew in strength in the North, calling for the end of slavery nationwide and exacerbating tensions between North and South. The American Colonization Society, an alliance between abolitionists who felt the races should be kept separated and slaveholders who feared the presence of freed blacks would encourage slave rebellions, called for the emigration and colonization of both free blacks and slaves to Africa. Its views were endorsed by politicians such as Henry Clay, who feared that the main abolitionist movement would provoke a civil war. Proposals to eliminate slavery by constitutional amendment were introduced by Representative Arthur Livermore in 1818 and by John Quincy Adams in 1839, but failed to gain significant traction. As the country continued to expand, the issue of slavery in its new territories became the dominant national issue. The Southern position was that slaves were property and therefore could be moved to the territories like all other forms of property. The 1820 Missouri Compromise provided for the admission of Missouri as a slave state and Maine as a free state, preserving the Senate's equality between the regions. In 1846, the Wilmot Proviso was introduced to a war appropriations bill to ban slavery in all territories acquired in the Mexican-American War. The proviso repeatedly passed the House, but not the Senate. The Compromise of 1850 temporarily diffused the issue by admitting California as a free state, instituting a stronger Fugitive Slave Act, banning the slave trade in Washington, D.C., and allowing New Mexico and Utah self-determination on the slavery issue. Despite the compromise, tensions between North and South continued to rise over the subsequent decade, inflamed by, amongst other things, the publication of the 1852 anti-slavery novel Uncle Tom's Cabin, fighting between pro-slave and abolitionist forces in Kansas. Beginning in 1854, the 1857 Dred Scott decision, which struck down provisions of the Compromise of 1850, abolitionist John Brown's 1859 attempt to start a slave revolt at Harper's Ferry in the 1860 election of slavery critic Abraham Lincoln to the presidency. The Southern states seceded from the Union in the months following Lincoln's election, forming the Confederate States of America, and beginning the American Civil War.